Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're doing a criminal law update about two recent developments. One is a case about random car stops by police in Quebec and whether those stops are unconstitutional. The other is about the shocking murder of a homeless man in Toronto by a swarming gang of teenage girls. What happened in each of these cases? We've got a lot of ground to cover today, so let's get into it with our criminal law panel from Titan Defense, Kabir Sharma and Sina Shabastari. Kabir, let's start with you. Let's start with the Quebec car stops case. The case was brought by Joseph Christopher Luamba, a 22-year-old Black resident of Montreal, who said that he had been stopped by police nearly a dozen times without reason and never given a ticket. What more can you tell me about Mr. Luamba's case?
So to understand a bit more about Mr. Luamba's case, I think we need to understand first and foremost that police have the ability to stop basically any vehicle on the road if it's for the purposes of ensuring the vehicle is properly insured and registered, and if the driver is properly licensed. So police are already given that power by our courts and by our government. So he was an Haitian immigrant who's had a driver's license since about 2019. About 3 times in a year, he was stopped by police and questioned. They just identified him and they let him go all 3 of these times. The case also had a few other people testify, all individuals Black, indicating that this was a practice that the police engaged in quite often. So what Mr. Luamba did was Mr. Luamba challenged the ability for the police to randomly stop vehicles on the road, either through the common law, which is the power given by judges, or power given to them through the provincial Highway Traffic Act that they have, and brought the argument that these types of powers that police have result in racial profiling or arbitrary stops.
So it was a challenge then under Section 15 of the Charter, which is our guarantee of equal treatment and benefit under the law. Sina, is there anything that you can add about how he argued this case, what was being argued?
I think the important factors to remember here for your viewers, Christine, is that, first of all, there were no charges laid in any of these stops. And secondly, the stops were effected in a short period of time with some persistence, as Kabir said correctly, 3 times within a span of 1 year. The court in these instances, what they do is they try to temper individual civil liberties versus the public's interest in keeping and maintaining a safe society. I think that's the backdrop with which we need to look at this case.
So what exactly then did the court find, Sina, about the random police stops?
What the court found here was that while initially there was the Supreme Court of Canada case of Ladouceur in 1990, and when that was decided, the court was split, there may have been a public safety reason for permitting the police to stop vehicles on the road. Now, we as a community understand racial profiling more, and the police's ability to randomly stop people can result in racial profiling, a practice we as society are trying to eliminate. So what that means is that we want to limit this highly discretionary power if it is being used in the wrong way. And the court found that this is precisely what happened here. And when something has no explanation, we really need to start looking deeper and read between the lines.
Kabir, is there anything you want to add there about what the court decided in this case?
I think, Christine, it's important to understand that racial profiling is never overt. So nobody's here saying that the police are overtly profiling certain people of color. What happens is the court has now recognized that these types of biases are subconscious, that they are ingrained in the way that we as a society operate for a variety of very complex and complicated reasons. So what the court is trying to say is that perhaps it's a systemic issue with the police in which the way that they're trained, that the police officers don't even know that they're racial profiling, but yet they're following their training and they're engaging in those behaviors. So it's a very complex issue that we've now begun exist, as Sina said, and we're now in the process of correcting.
We've got to go to commercial break now, but when we come back, I want to get further into this issue and how it is different from something our viewers may be familiar with, carding. Welcome back to Canadian Justice, where we're discussing a recent case out of Quebec about random police vehicle stops. Now, Sina, our viewers may be familiar with a term called carding, which is slightly different from what this case dealt with, but which has some similarities. What is carding and what is its legal status in Canada, and might this decision change it?
Indeed, and I'm sure a lot of your viewers are familiar with carding because it was a big deal. Carding is random stopping all the same, but the distinction with carding is that it happens when police are on foot patrol rather than making a stop roadside of a motor vehicle. And that's the element that's different. And carding all the same recognized after a breakout study, which showed that it was ethnic minorities and people of color and people in the lower socioeconomic demographics that were being disproportionately targeted with respect to carding. And once that was showed, then carding was effectively no longer legal and allowed. And again, it was as a result of that breakout study that showed that.
But it wasn't a court decision that came to that conclusion. It was a policy decision. Is that correct?
Indeed, it was due to the study that came out, which was unequivocal evidence that these people were being targeted more so than any of their other counterparts.
So I wonder if the decision in this case, although it is a lower court decision, might have any impact. Kabir, I want to talk to you about how this is a change in the law, because Sina mentioned a 1990s case, R.N. Ladoucette, where the court found that random stops were constitutional, that they were the only way to determine whether drivers are properly licensed or if a driver is impaired. So what has changed between 1990 and today?
I think, Christine, that the major point that's changed is that we have a more nuanced and more, I guess, solid understanding of what racial profiling is, how it comes about, and what we can do to eliminate it. This is, even to this day, a highly contentious issue within the courts and amongst the people as a whole. Now, once you have ingrained in your mind a sense of this is the way how things are and how they function, it's very hard to change that. And I think the difficulty is that we're too used to applying standards from way before to standards of a more multicultural, more diverse society. And the court is recognizing that, and the court is now understanding that needs to be changed. In 1990, we didn't have, for example, the computer system and the way that police can check whether or not a vehicle is licensed or registered, how they have that now. So there are a variety of changes which have brought upon this massive policy change, which I believe is well welcomed in our diverse community.
One thing that they can't get from technology, though, is the understanding of whether or not a driver is impaired. So I wonder how this might impact programs like RIDE, which is pulling over cars. I mean, all our viewers know what RIDE is because we all get pulled over at some point in a RIDE program. Would that program be affected by this decision? Sina.
So RIDE. Oh, sorry. Go ahead. Go ahead, Sina.
I think no, and there is a real live reason as to why that's the case, which is RIDE programs, which is of course, reducing impaired driving everywhere, is again tempering what I mentioned before, which is independent rights versus society's interest to keep the road safe. That being said, there's an element that's missing in RIDE. RIDEs are indiscriminate at the first instance. It's completely random. Now, once the individual is pulled in and pulled over or waved in to go to secondary, if you will, for sure, the discretionary power of the police kicks back in. But in the first instance, it is indiscriminate. And I think that's where it will be saved with respect to the issues that we're talking about today, and that it will remain.
Yeah, there's no discretion in ride. Everyone gets pulled over if they're driving on that road. Now, Kabir, we've got about 30 seconds. This case was out of Quebec. Are there going to be implications for other provinces at this point?
I can say absolutely. The implications are that now that lawyers know that these types of law are challengeable in their own province, there's not a doubt in my mind that this is some doors have opened where other lawyers are going to be challenging this. I can tell you that there's a section of the Highway Traffic Act, section 216.1, that permits the police to give the police the power to pull over individuals like this.
And I imagine now it's going to be challenged. We've got to go to break, Kabir, but we'll be right back. Welcome back to Canadian Justice. We're doing a criminal law update with Kabir Sharma and Sina Shabastari of Titan Criminal Defense. Now, guys, I want to turn to a case that has shocked so many people in Toronto, the murder of a homeless man by what police have called a swarm of teenage girls. Kabir, what do we know about this case so far?
So what we know is that there were a group of about, I believe, 12 to 16-year-old girls. What I've heard from the police is that they've met up on social media. They were engaged in some type of criminal behavior at some point in downtown Toronto. They got into a bit of an argument or a tussle with a gentleman who is homeless and his companion. These young girls tried to steal this alcohol from the companion of this gentleman. He tried to jump in and stop this robbery from going on and was stabbed by perhaps one, perhaps more of these girls. And quite frankly, it is a very shocking and unexpected crime to happen in Toronto.
Sina, is there anything you want to add to that description? And one of the things that stands out to me is I've never even heard of this term swarming before. Is this like a new phenomenon? Because since hearing the report of this, I've heard of another swarming attack, this time by teen boys that took place in Alberta.
Absolutely. So I think what we need to know with respect to swarming is that, first of all, that's not a new phenomenon. It is something that in law we've recognized for quite some time, especially as an aggravating feature when it comes to sentence post-conviction. It aggravates the offense. What the viewers need to remember for a case like this is that, first and foremost, the offenders here are youth offenders, and therefore they are legislated and prosecuted under the Youth Criminal Justice Act, which is the YCJA, which operates with its own set of rules, which I'm sure we can cover later on. And also that given the swarming element and nature of this case, and given the fact that youth are involved, there's not a lot of information that we have. So even though it comes with a lot of shock and awe, and of course not to trivialize the fact that there is a deceased individual, a deceased vulnerable individual in this case, in my view, it's entirely too early to really determine the degree of responsibility and culpability as between this group of youth offenders, or alleged offenders, rather.
Yeah, let's talk about the age of the accused here, because Kabir, the murder was committed by this group ranging, as you said, from I think 12 or 13 to 16. So they're governed by the Youth Criminal Justice Act. What type of impact could their young ages have on the outcome of the case? Particularly, is the procedure different? Are the sentences available different? What does this mean that they're so young?
So the procedure is different. The procedure that they're governed under, like Hasina said, is the Youth Criminal Justice Act. The Crown can decide whether or not they'd like to prosecute these young girls as adults or as children. If they're prosecuted as children, they're subject to a maximum sentence of 3 years, even for first-degree murder. However, if they're prosecuted as adults, they're subject to a maximum of life imprisonment. One thing that the Youth Criminal Justice Act understands is that young people are of a diminished moral culpability, meaning that we understand that scientifically, young people's brains aren't as developed as adults, which affects the way that they think and the way that they act. So the Youth Criminal Justice Act influences that. However, that doesn't stop the Crown from prosecuting them as adults if they so decide.
And Sina, can you give any insight into what factors go into the Crown's decision-making if they decide to proceed as adults or minors?
I think certainly the severity of the offense is one of the biggest things that they have to deal with. Secondly, and importantly, it's whether there is a level of recidivism involved and whether the young offender is an individual that has faced criminal charges in the past with some level of frequency. What is important to note, and it's in fact written in the preamble of the YCJA, is that a custodial sentence is always the last resort for any youth offenders for the reasons that Kabir just mentioned, and that rehabilitation, given the young age of youthful offenders, is at the forefront of the court's mind because they have the highest prospect of rehabilitation.
Mm-hmm. We've got to go to a commercial break now, but when we come back, I want to talk about the perceived rise in violent crime, and particularly in major cities in Canada. I'm sure you guys have a lot of insight into that as criminal lawyers. We will be right back. Welcome back to Canadian Justice, where we're doing a criminal law update, and we're discussing, in particular, this swarming attack in Toronto by a group of teenage girls that led to the murder of a homeless man in the city. Now, Kabir, there's a sense among a lot of people in the public that violent crime rates have been going up in general. How accurate is that perception? And if it is accurate, do we have any insight into why?
I think that the perception of violent crime going up may be accurate, but statistically, Toronto has had a decrease in violent crime over the last decade or so. I think the perception largely is due to the proliferation of social media now. I feel like news is a lot more accessible and a lot easier to kind of manipulate for the general public. And we see it all the time in our general news stations. We see it on our Instagrams, on our Twitters. These are the kind of things that people like to read about. And these are the kind of things that typically result in higher ratings for a lot of media outlets. So has violent crime been increasing? Statistically, no. The perception of it has absolutely.
Sina, what about the perception about violent crime committed by strangers in particular? This case, this swarming attack, was a group of strangers murdering. The girls were strangers to each other, and they murdered this homeless man. How much do we know about violent acts that are committed not by someone you know, which I know is so much more common, versus violent crimes committed by strangers?
Of course, I think I can say safely that anecdotally, I haven't personally in my line of work noticed an increase or an influx on stranger crime. This is something, Christine, I've discussed on your show previously. I think there is an element of public pandering that goes into these things. And Kabir, I think, hit the nail right on the head. What we see and are bombarded with in media and images effectively, and what we seek is violent offending, what's happening, where are the shootings, who's getting stabbed, which youth are committing offenses. Nobody ever reports, for example, this young man volunteers his time at a shelter, or somebody has done something good for somebody, because it just simply doesn't sell effectively. That seems to be not of interest to a lot of people. Lastly, what I would remind your viewers to remember is that we have had quite a rough number of years in the recent past. The pandemic meant such that we were confined and people are frustrated and they may have tempers that flare more easily these days. So that may be an explanation as to why we're seeing this, especially with youth who have been cooped up for a number of years without interactions.
Yeah, I mean, I don't want to play into the media concerns that you've both laid out now, but I have to say that there is a big shock element to the swarming case. And I think one of the things, I mean, there was a lot of things about it that are shocking, but part of it is that the age of the defendants and that they were, frankly, that they were female. Because Kabir, I know most criminal defendants or male. What can you say about the unusualness of the gender of these particular accused?
This is highly, highly, highly unusual. And I can tell you, this is one of the reasons why it's gaining so much media attention. It was shocking to me when I heard it. And let me tell you, I've seen everything doing this show for close to it. And what the explanation for this is, I don't know. We can sit here and speculate all day about why these people did this. But I think Sina made a good point in a sense where you have a 13-year-old girl who, for the last 2 years, has been sitting at home. The only interaction that this girl's had has been through social media. They've been communicating with friends through social media. For 2 years, being locked up at home is different from someone who's 33 to 35 versus somebody who's 11 to 13.
Especially if they have a challenging home environment. And what I read about the bail proceedings of these defendants was a number of them, their families didn't even show up to the bail proceedings. Unfortunately, that's all the time that we have today, but I want to thank you both so much for coming on.
Thank you, Christine. It's been a pleasure being back.
We've heard today about two fascinating developments in criminal law, a case about random car stops and racism, and about the horrendous murder of a Toronto man by a young group of girls. What is your take on these developments? You be the judge. I'm Christine, and remember, a freer Canada starts with you.